Thank you, Mr. Chairman. Mr. Torrillo, in your testimony, you say that a much discussed part of the Act is the requirement that banks push portions of their swap activity into affiliates or face restrictions to their access at the discount window to deposit insurance. That kind of, I guess my question is, what percentage of I think the gentleman, Mr. Lynch, a minute ago made a comment about 97% of the trades are done by 5% of our 5 banks. Is that basically correct?
I think that may be a little bit high, I think.
Yeah, I would say it depends on the market. In the commodity swaps market, it's far more diverse and many more participants.
Okay.
In the interest rate market, it is pretty concentrated.
Okay. The point I want to get at, though, is the risk that the banks have with these entities that are under their corporate umbrella that would be exposed to FDIC insurance. I think it's imperative that we get those out so we minimize exposure to not only to the banks but to the taxpayers. And wondering where you're at with that and how your rulemaking is going on that.
Well, the rulemaking is the joint rulemaking, of course, by all the regulatory agencies, and we don't have a proposed rule on that out yet. I'm happy to get back to you with the status of where we will be on that.
Okay, I think that's very important because I think otherwise we're getting the taxpayer on the hook again for some risky behavior that was the cause of the problem, and we still have them there rather than getting it out of the depositor's pocket.
And Congressman, sorry, but as one of your colleagues was asking earlier about the coordination of rulemaking, and of course this is somewhat related to the Volcker rulemaking as well, because you have the same set of issues of activities being moved out of organizations.
Okay, along that same line though, with other federal entities that have branches here in the U.S. and then have access to the Fed window, how do you minimize our exposure to them through this rulemaking authority?
Well, actually, Congressman, as the statute is drafted, it appears as though the exemption that is provided for insured depository institutions for some kinds of derivatives activities, so government securities and agencies and high-quality bonds, would not be applicable to foreign branches of, domestic branches of foreign banking institutions. So actually there is an asymmetry there which has been brought to our attention by foreign governments.
Okay, in your testimony you say that they may require foreign firms to recognize their existing U.S. derivatives activity to a greater extent than U.S. firms.
Right, that it might require them to restructure in order to have it outside of any insured depository institution.
Why, I guess the question is, how concerned are you with the ability of foreign entities to be able to access our Fed window and have our taxpayer dollars involved?
Well, Congressman, all borrowing at the discount window is fully collateralized with haircuts, and that applies regardless of who is accessing the discount window. Also, of course, discount window access is contingent upon supervision, which assures that we or our colleagues in the other banking agencies have adequate knowledge of the liquidity and capital position of the institution accessing the discount window. So it's only when there is supervision here and when we have full collateralization with appropriate haircuts that discount window lending is possible.
Are you looking to revise those rules and the circumstances around them right now with what's going on in Europe?
Not provoked by anything going on in Europe. Pardon me. We're of course always looking at the appropriate haircut levels and whether there need to refine our discount window access features. But as I say, any accessibility is going to be based upon an entity present here in the United States, which is supervised here in the United States.
Okay, thank you. My time's about up here. I just got a real quick question for basically all of you. One of the things that is a concern to everybody here today is end users. Do you all recognize that they were not a part of the systemic risk of the problems that were in 08? Is that an agreed to statement, or is that not?
They didn't cause the problem. They ultimately were
caught up in the problem.
They got caught up into it, and I fear in the future also that we want to have a freedom to fail. The large banks have to be able to be allowed to fail. And so
Okay.
part of that's to make sure they're
Okay,
not
I'm running out
interconnected.
of time, but I understand but by the same token, if they're not part of the problem, you've raked them into the problem, and yes, there's by doing this, you now, if we don't go with the letters of intent from Senator Dodd and Senator Lincoln about what was going on here with regards to not imposing some sort of other barriers to end users, we may get there. And I think this should be a very narrowly focused ruling and regulatory mandate from you, and not impose other additional risks or concerns onto the end users.
I'm agreeing with you that the CFTC does not intend to have a requirement of margin with these non-financial end users.
Okay.
But they did get caught up in the problem.
Chairman Shapiro, I agree. I assume you agree with that?
We haven't formulated any proposals in this area yet at the SEC, but I think it's safe to say we're extremely focused on this concern that's been raised multiple times this morning. The end users likely to be using the very narrow category of swaps that we regulate are going to be financial institutions.
Okay,
It wouldn't be
my comment is
commercial or
they're not the
any
problem,
person.
so let's don't make them a problem
We're not gonna make them a
by
problem.
posing rules and regulations that they don't need. Okay? Thank you. Thank you, Mr. Chairman.